Honor, we would, the court's indulgence for that usual time period would be acceptable to us.
Okay, so we will not take up that motion at this time. Of course, the Marazzo, you're certainly free to stay on. I'm sure that you and your clients are interested in what is happening, but we will address your motion to intervene at a later date.
Thank you, Your Honor. If I may just say and request, Your Honor, that if the court is inclined to reach the merits of this appeal, that decision not be delayed because of my motion to intervene. I think that the court can and should decide this entire case with or without us here, but we do have something to say, but we don't want to delay that.
We have a motion to stay that's been filed and opposed.
Yes, Your Honor. The other preliminary matter, so that I know because I was offline, is there anyone there for the City of Sunland Park?
Not hear anybody.
Your Honor, what had occurred in this case, Mr. Bradley Springer's firm, and he and his associate had asked to intervene in the case. They were allowed. They filed briefs, and subsequent to that, the City of Sunland Park terminated their contract with Sunland Park, and we have not seen in this case or in the Supreme Court case that's associated with this on an earlier matter, there's been any entries of appearance. And so I'm a little concerned about that as well. We didn't include that in our motion to stay because we were kind of expecting someone to enter an appearance for them. But it's obviously within the court's discretion when a party doesn't appear as to how to handle that, but they apparently are not here.
It is odd. See how far we get this morning, I suppose. So on the motion to stay, the county is opposed and believes that the matter proceeding in front of the Supreme Court will not affect the outcome of this litigation one way or the other. Do I have your position correct, Mr. Audio?
For the appellants in this case, Your Honor, we believe that the Supreme Court decision absolutely affects the outcome of this case because it will in fact determine what boundary line is in existence to incorporate or not incorporate. So it's tied to the same issue that we raised at the original appeal here, the original hearing for incorporation in this case, because the Court of Appeals case was pending. So yes, Your Honor, it very much does affect the outcome of the case for the attempted incorporation.
And Mr. Gooden?
The county disagrees with that. What is before the court is whether or not they met their burden under the determining the municipal services. As we get down the road, and if this annexation is upheld, it may have some other ramifications, but I don't think it really affects the court's ability to determine this case. And as I set forth in my response, there's really only two ways that the Supreme Court can uphold the annexation. And that's to either find that the county never acquired jurisdiction, which the district court held originally, or that somehow the county lost the jurisdiction after it was maintained. In either of those, the jurisdiction for the incorporation would not exist, and therefore the incorporation would fail. So I really don't think it has a bearing what's going on in the Supreme Court has any bearing on what is before the court today. And staying it is just going to delay this. As I set forth, this has been going on in this case, for this incorporation attempt since, I said 2015. That's when the first hearing was. The original petitions were actually filed in 2014. It took a couple of attempts to get a petition that was appropriate, but so this has been going on now for a long time, and it's just delaying the ability for an entity to determine who's going to be the local government over these particular areas.
Your Honor, if I may have a reply.
Yes.
I have a great amount of respect for Mr. Gooden as a county attorney in this matter. He is essentially the referee in a dispute that has been occurring for many, many years between the citizens of Santa Teresa and the government of Sunland Park. Although he needs to be clear about the record, the first delay in this case of a period of 5 years occurred because of the position that the county took on interpreting the statute in question of when you can incorporate in an area that already has an established municipality in it. They in fact took a position that or meant and it took us all the way to the Supreme Court, back down to the Court of Appeals to win that case, to say the county's interpretation of that is wrong and we can attempt to incorporate. Then the remand happened and we come back to the court. And just bear with me a minute, Your Honor, because this theme is important throughout. Then we get back on a remand from the Court of Appeals, and Mr. Gooden's statement that this is irrelevant was directly contradicted by the Court of Appeals. On page 14 of its decision, it stated, put simply, we can only now appreciate that the continuing annexation proceedings at issue in the instant cases would never have been initiated and certainly should not have proceeded to the extent they have, given our previous holding in Provisional 1, that PGOST incorporation petition complied with pertinent statutory requirements and the prior jurisdiction attached. The court goes on to say, further, we now agree that Socorro Partners and Sunland Park's arguments to the contrary, we would, number one, necessarily render the incorporation litigation, which has traveled between the county, the district court, and this court and our Supreme Court, a nullity. That is what is at stake. Mr. Gooden took the position that it was irrelevant what the boundary of the incorporating entity was, and that whether parts of it had been annexed in the interval was relevant. We absolutely say it is. Under 321 of the New Mexico statutes, which are the required incorporation process, then for counties that are for applicants for incorporation that are in a developed municipal area, they have to follow additional requirements. But for 321, the requirement is you have to describe the territory proposed to be incorporated as municipality. It has to be signed by 200 qualified electors, which it was. If all of those electors still are in a non-annexed area, the petition shall be accompanied by an accurate map or plat that shows the boundary of the territory proposed to be incorporated, and a municipal services plan, and whether they can afford to create a municipality, all depend on those boundaries. I would not hesitate to say that if we had come into the county and told them, we're not sure of our boundaries, county, we may have an annexation, part of this going away, but we want to go ahead and apply for incorporation, that we would have been kindly shown the door until that had been resolved. That's why prior jurisdiction is important. It's kind of like water rights or property interests. First in time matters. And we filed our incorporation petition before Sunland Park annexed. and they continued to annex even while this case was pending, despite our warnings that the law of New Mexico was clear that we had prior jurisdiction. Now for Mr. Gooden to say this has taken too long, almost everything that he has done has delayed a final disposition of this case, Your Honor. And along with the actions of Sunland Park, I'm not saying it was all the county's fault, but Sunland Park, over our pre-existing incorporation, attempted to annex and did annex multiple parcels, including Mr. Morazzo's clients, over our objection. And the Court of Appeals ruled in our favor, and now they're in a la land place where they don't know what's going to happen. So I appreciate their quandary, but it was self-induced. And we simply want to have a fair hearing, know what the boundaries of the proposed incorporation would be, and let these citizens' voice be heard.
This audio, do you have a sense whether or not, at least with respect to all questions in this case, can they be answered without the City of Sunland Park's participation?
Well, if I was representing Sunland Park, I wouldn't appreciate that, Your Honor, because, as I said, they are really the party who is in opposition in this case, because the county is the referee that considers these incorporation processes. And while Sunland Park may have chosen to silent itself and not take a position without a pleading indicating that, I believe we may be creating another appealable issue. And I don't want to spend any more my client's money running back and forth between appellate courts. So based upon that is a new added fact, plus the fact that until the Supreme Court tells us what the boundaries of the incorporated area are, I think we are wasting the court's time arguing this today.
Mr. Morazzo, I think I heard you take a position on the stay, and I'd be interested to hear what you and your client's position is.
Thank you, Your Honor. Yes, we definitely are opposed to any stay of this proceeding, Your Honor. My client is a owner of 229 acres of land that are within the incorporation map. And what happened was the proposed incorporators went and included my client's land without telling them, without notifying them, without seeking their approval. They pretty much did that in secret, and unilaterally determined, oh, your land is going to be in our proposed city. We didn't know anything about that. So my client, since before this petition for incorporation, had been in talks and application process with the City of Sunland Park to annex the land and develop it into what by now should be over 3,000 new residences, which would have brought tremendous economic development to the area and benefits to everyone, jobs, employment, and so forth. That had been stalled and has been waiting since pretty much 2014, because the folks that seek to incorporate here, represented by Mr. Alshio, filed this unilateral petition to incorporate. And then they come to our case, and then they say, you cannot proceed because your land is part of this incorporation. Okay, at the time that we filed our petition to annex, the incorporation was dead. It had been denied by the county, so there was nothing pending. So we sought to annex, we did annex. We have a development agreement with the City of Sunland Park. We have ordinance approving.
But also, I have read your pleading, but you're arguing the merits of your pleading. What I was asking is your position on the stay, and you think that the Supreme Court's decision has no bearing on anything that's in front of this court.
I believe that, Your Honor. So let me address that directly. This is an appeal pursuant to 39-3-1.1. That statute that permits this administrative appeal expressly sets forth what this court is going to do. And in this case, the court is going to determine whether to reverse the county's decision on only three bases. Number one, the agency acted fraudulently, arbitrarily, or capriciously. There's nothing that will happen with the Supreme Court that will change the court's determination of that. That hasn't been alleged and probably can never be proven here. Number two, the final decision, that's the decision by the county below, was not supported by substantial evidence. Well, the record, the administrative record in this case is full, it's complete. There was plenty of evidence. No evidence was excluded from the petitioners here. And the order that was entered recites all the evidence that was considered. So you would be looking at just a review of the administrative record. There's nothing that the Supreme Court will do that will change the question of whether or not the proceeding below was supported by substantial evidence. The last is the agency acted not in accordance with the law. Well, the agency, in this case being the Board of County Commissioners, acted precisely in accordance with the law in direct response to what the Court of Appeals told them to do. They went back and they had a hearing on the merits of municipal services. So those three questions are completely unaffected. The issue in our case is not the boundary of the incorporation. That is not what the Supreme Court is going to decide. The way that case happened was there was an administrative appeal like this one of the annexation ordinance by people who weren't property owners. Therefore, they lacked standing. And then there was a simultaneous lawsuit declaring that the annexation was invalid pursuant to the doctrine of priority of jurisdiction. We filed a motion to dismiss under Rule 12b-6, and that was granted at the trial court level. That went up on appeal to the Court of Appeals, and that was reversed. That is now on appeal to the Supreme Court, where the decision will be by the Supreme Court. Was the trial court correct or not in granting the 12b-6? That's that issue. So if that is reversed, as we hope, if the trial court is affirmed, as we hope that it is, then we have a dismissal of a lawsuit. That's all we have. And if it is reversed, then we go back to the trial court for further proceedings, where we are going to argue further and have counterclaims and do a lot more. That has nothing to do with the administrative review that's at issue in this case. And by the way, Your Honor, I think this issue of the stay has been waived because this is an appellate review. This administrative review is in appellate fashion. I don't believe there's new evidence that should be admitted here. I don't believe there's new anything. The court will look at the administrative record to decide whether it was done correctly. Before the county, there was no request to stay the proceeding pending the decision of the other case. So that's waived. They proceeded to the merits. They had a hearing on the merits. They failed because they should fail. If the court reads that order, it's very clear that they cannot provide municipal services faster than the city of Sunland Park. So that's waived, in my view, on this appellate review type. And the cases are independent. This should be decided first because our other case depends on this one, not the other way around, Your Honor. So for those reasons, we would ask that or not grant the stay and just decide the case based on the record from below.
Your Honor, may I respond to that argument on the merits? And we don't need to go to the merits. Let's stick with the stay, but
just
is
a
that
second.
appropriate?
Mr. Narasso, what's your position on proceeding here without the city of Sunland Park participating?
Well, Your Honor, I would certainly love to have them argue because I know that they argue consistent with our position. They have the annexation with us. I do think that the administrative review that this court has to do under the statute, under 39.3.1.1, it's a pure legal review of the record below. And their position is clear, it's the same as ours. The county's position is clear. The petitioner's position is clear. I think it can be decided, in my opinion.
Okay. And go ahead, Mr. Audio.
Mr. Marazzo is taking the same position that he has taken all along, and including in front of the council for the city of Sunland Park when they granted this annexation, when there was a pending incorporation. And the concept that the amount of land or the boundary of the land to be incorporated was irrelevant for the county of Doña Ana to consider this is absurd. That is the very nature of an incorporation. We do not know what that boundary is, and we won't know till the Supreme Court acts. So I appreciate his situation. Again, it is self-made. They chose to proceed with the annexation over the clear law of New Mexico that there was prior jurisdiction in this incorporation action. Secondly, he is absolutely wrong from the perspective of the incorporation. As I said, we have to know the boundary. Therefore, we cannot provide adequate estimation of services. We cannot, 6 years has passed, Your Honor. The county and the city argued, well, we had plenty of time to create a service map. But as Ms. Gonzalez before the county commission stated, we are still trying to determine whether this illegal annexation is going to stand. And that until the Supreme Court does that, we cannot proceed. So we obviously see the case in very different ways, Your Honor. And the stay is just another mechanism to get the ultimate relief we wish, which is a remand with a stay until the Supreme Court decides, and allowing us to create and meet our statutory obligation to show we can provide services in a timely manner when we know what the boundary of the incorporated area is.
So I guess, Mike, maybe you can clarify the timeline for me. This is an appellate review. The merits were in front of the county commission. Was the issue of this needing to be stayed pending the review by the Supreme Court of the City of Sunland Park's annexation? Was that not true at the time that this was in front of the county commission?
Yes, Your Honor, and by letter, Ms. Gonzalez asked that this be stayed until the Court of Appeals case at that time was decided, and argued that we could not present such evidence with that case pending. There was a motion on whether to stay it or not, and there was the provisional government was sent to Teresa, and Ms. Gonzalez lost on a vote of 3-2, and they proceeded.
Got it.
And Your Honor, that is one of the issues in their statement of appellate issues, is whether that decision to go forward was arbitrary or capricious. So that's one of the issues before the court right now, is whether or not there should have been a stay, or they didn't call it a stay, they called it to postpone it until the Supreme Court ruled. So that is one of the issues before the court, is whether that decision not to postpone it was arbitrary and capricious. And one of the reasons the DOCC did not is they had a court order from the Court of Appeals and the district court to hold a hearing. It didn't say hold a hearing after the Supreme Court, it said hold a hearing. So that's what the DOCC did.
Your Honor, respectfully.
I do appreciate everybody clarifying the written record here. There's a lot of moving pieces that you all are much more familiar with than I am. I think you've answered my question to allow me to make a ruling on the motion for stay. I will take that under advisement, as well as under advisement what, if anything, to do about the City of Sunland Park's participation or lack of participation. If I need a hearing on that or an order to show cause or something, I'll certainly notice all parties so you can participate. Pending a ruling on the Socorro Partners motion to intervene, would certainly provide notice of anything that is filed. I don't know, Mr. Marazzo, if you are a service contact in this case, but if you are not, if you could make yourself one, I would appreciate it to make sure that nothing is missed.
I will, Your Honor. Thank you.
Thank you, Your Honor.
Thank you all. I'll get that ruling out as I can. Like I said, if I need to get the City of Sunland Park's involvement prior to that ruling, I will let you know as well. So have a good morning.
Thank you.